Tenant liable for any damage to rental home until tenant returns keys to property manager issue. The tenant leased a furnished condo that included a flat-screen plasma television. At the end of the lease term, the tenant never returned the keys to the property manager. Instead, the tenant telephoned the property manager to state that the keys were left on a table inside the furnished condominium. When the property manager went into the furnished condominium, the property manager could not find the keys and the flat-screen plasma television was gone. Is the tenant responsible for the flat-screen plasma television? Answer: probably. At the end of the lease term, the tenant is required to deliver possession, i.e., return the keys to the property manager. Until the keys have been returned to the property manager, the tenant is probably liable for any damage or loss to the furnished condominium, including the loss of the flat-screen plasma television. Note: under the AAR lease at lines 109-111, the tenant is specifically liable for any damage or loss to the rental property until the keys have been returned, and leaving keys in the rental property is specifically not considered returned. Unlicensed assistants cannot collect rent facts. A real estate licensee manages a number of rental properties. As part of their management, the real estate licensee directs tenants to deliver payment to the licensee's unlicensed assistant, who is to count the money and issue a receipt. Issue: is the unlicensed assistant permitted to perform this task? Answer: no. Discussion: the Arizona Department of Real Estate has issued a Substantive Policy Statement, SPS 2017-01, titled Unlicensed Assistants. That SPS states, in part, that an unlicensed assistant shall not collect or offers, attempts, or agrees to collect rent for the use of the real estate. As a result, the unlicensed assistant, in this case, would be prohibited from collecting rent, counting the money, and issuing a receipt. A buyer must honor an existing lease. After close of escrow. Facts: a listing just went under contract. The tenant's lease doesn't expire until August. The buyer wants to occupy the property and wants the tenant out by close of escrow. Issue: should the property manager give notice to the tenant that he/she will need to vacate the property in 30 days? Answer: see discussion. Discussion: the general rule is that the purchaser of a home, or any other real property, has to honor the existing lease. The buyer is further deemed to have notice of the lease by way of constructive notice. Accordingly, the buyer must honor the remaining term of the lease. The tenant should be provided with a notice of non-renewal of lease agreement at the end of the original term, which should be given on or prior to the periodic rental due date. Note: a lessee has the right to possession and use of the premises so long as he is not in default of any of the terms of the lease. Camelback Land and Inverse Comer v. Phoenix Entiamet Corp., 2 Ares App, 250, 407 P2, 791, Ares App, 1965. A landlord may treat a residential rental as abandoned under certain circumstances. Facts: the tenant has been absent from the residential property for at least 2 weeks, and the landlord believes that the tenant has abandoned the premises. Issue: has the tenant abandoned the premises pursuant to the Arizona Residential Landlord and Tenant Act? Answer: see discussion. Discussion: because the tenant's personal property remains in the unit, a finding of abandonment under the Landlord-Tenant Act requires: 1. The tenant has been absent from the unit, without notice to the landlord, for at least 7 days. 2. Rent is more than 10 days past due. And 3. There is no reasonable evidence other than the tenant's personal property that the tenant is occupying the residence. CARS, Perv 33, 1370J. Assuming that the aforementioned elements are established, the tenant will be deemed to have abandoned the property under the Arizona Residential Landlord and Tenant Act. A residential landlord may only demand security equal to 1 1/2 months' rent. Facts: the landlord leases his condominium for $2,000 per month. He demands that the tenant pay a security deposit of $3,000. He also demands that the tenant pay the last month's rent of $2,000. Issue: is this practice consistent with the Arizona Residential Landlord and Tenant Act? Answer: no. Discussion: ARS. Paragraph 33, 1321 prohibits a landlord from demanding security, however denominated, including prepaid rent in an amount or value of more than 1½ months' rent. Thus, the landlord may not demand a $3,000 security deposit, and that the tenant pay the last month's rent of $2,000. Note that ARS, paragraph 33, 1321, does not prohibit a tenant from voluntarily paying more than 1½ months' rent in advance. A residential tenancy remains enforceable, even after the owner sells the property. Issue: what are the rights of a tenant when a residential property is sold during the term of the lease? Answer: the new owner will take the title subject to the rights of tenants in possession. The terms of the lease agreement will, therefore, control the new owner's rights and obligations to the existing tenant, provided the terms do not conflict with the Arizona Residential Landlord-Tenant Act, ARS, paragraph 33, 1314A. Accordingly, the lease will pass with the land, and the new owner can only oust the tenant in accordance with the terms of the lease.